Dear Indigenous scholars, students, colleagues, friends, thanks for these possibilities to speak at the conference of Indigenous Study at the United Kingdom of Europe. It is an honor to be invited by the Indigenous Study discussion group to speak on a topic what I have spent much time on researching the last year, and particularly here at the University of Cambridge. Before I go into my topic, I would like to mention a few words about the Arctic University of Norway, and particularly the Faculty of Law. We have ever since 1987 had both teaching and research on Sami and Indigenous law. Sami is the only Indigenous people in Europe, or at least in Northern Europe, and Norway has a particular responsibility for research and teaching customary law, etc., for the Sami people. So there have been produced many master theses and also rather many PhD theses from the University of Tromsø on this. And we have also several not mandatory courses for foreign students taught in English on Indigenous people issues and Indigenous people law. So then I go into my topic. I'm going to speak about how the international law, or how international commitments Norway have endorsed impact on Norwegian national legislation. And this is not interesting only for Norway, but since the treaty or the obligation I'm speaking about is is endorsed by most of the civilized countries in the world, it's have impact many places. I will return to that. The 1966 International Convent on Civil and Political Rights is in the core of my presentation. And it is probably the most important provision for protecting interference in both minorities and particularly Indigenous peoples' land and resources. It has been a part of the global community's human rights obligation since 1972. And for Norway, in addition, it became national law in 1999 when it was incorporated with the precedence over national law. In any case, it has, however, had greater importance in the political sphere than in the court of law in Norway. This was changed in the fall of 2021 when the Supreme Court of Norway ruled that the construction of two wind power plants were violating the rights of the Indigenous Sami peoples' reindeer pastures, pursuant to Article 27 ICCPR. So this presentation will be about Article 27, but it will also be about Norwegian law connected to that. And I will enlighten the article and the case law to determine the impact on protecting Indigenous rights, not only in Norway, but in a neighboring country with the same legal system, where they also try to exercise the green shift by building down nature and pastures. And important here, as the Norwegian case law is based on the Human Rights Committee's case law or practice, among other from Peru or New Zealand, the norms I will elaborate on have relevance for the protection of indigenous peoples' land right globally. And also, before I go into this, at least from Norway, we can see that there are two ways indigenous people can use for protecting their traditional livelihood, resources, and lands. One is to argue based on property rights. The other is based on international rules for protecting of minorities' cultures. In Norway, the latter has proven to be the most effective, since national rules on expropriation eliminate the physical protection of land rights of indigenous people. In other words, the state or the constructors, they can just pay money and then take the land. But looking at the cultural rights, that's not possible, and that's a big difference, and these things I will continue to elaborate on here. The judgment known as the Fosen case is unique in Norwegian law, as it is the first time the Supreme Court have concluded that an interference violates Article 27. In other words, the rights to enjoy culture for minorities, or in this case, the indigenous Sami. And the historic judgment is a result of an appeal against the case to determine expropriation compensation. It was not a question about the legality when it started. It was just a case how much money the constructors of the wind power plant should pay. The fact that the Sami parties contested the legality of the interference made the judgment to a discussion in principle scope of Article 27, which the Norwegian Supreme Court had to test. And that is the interesting part of it. I will in particular base on the case law, and for they who is interested, you can find the judgment translated into English on that link. So the main question the Supreme Court of Norway had to decide on was thus whether the expropriation case for measuring damage had to be denied. As a result of that, the license for building the power plant was invalid. And before we go deeper into it, we should, as lawyers always do, looking at the wording of the provision. And it reads like this: in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with the other members of their group to enjoy their own culture, to process and practice their religion, or to use the language. So that is the wording of the provision, and it is probably not saying everything what is behind it. Important here is that the Human Rights Committee, the monitoring body, has interpreted, and this interpretation I will elaborate on now, how the Norwegian Supreme Court use it. In any case, assumed breaches of the convent may, if national remedies are used fully, be brought for the Human Rights Committee, which is the monitoring body. And in Norwegian law, the Dispute Act says that if the Human Rights Committee find that the Supreme Court has given a, let's say, wrong sentence, it means that the case have to be reopened. And in Norway, it's fully practiced that the Supreme Court in a reopened case will follow the advices from the Human Rights Committee. And according to the wording, the provision imposes a negative obligation on the state not to deny the minorities the rights to enjoy their culture. However, the provision imposes a positive obligation to implement measures to safeguard the culture of minorities. This can be learned from the practice or the case law of the Human Rights Committee. Nevertheless, it's mainly the scope of the negative obligation that has been tested by the courts. Or, of course, also by the Human Rights Committee. The time do not allow me to go deep into the HRC case law. There is, however, 4 cases that should be mentioned in relation to protection of land right and traditional livelihood. There is 3 cases from Finland. All the parties there are a different member of the Lensman family versus the state of Finland. And the most important case, it is the Puma case from Peru. It has CCPR number 2006-4557, and it was heard in 2009. I will say some word of the last one, as it is the one the Supreme Court of Norway heavily based its argumentation on. The Puma case was based on a complaint from a member of the indigenous Aymara people in the Andes mountain. And here the HRC states that an interference that has a substantive negative impact on the cultural enjoyment is violating the convent. And this was the situation in the case as thousands of domestic animals, llamas and alpacas, died due to groundwater drainage and drying out of approximately 10,000 hectares of pastures used by the Aymara people. And that was due to a construction of a water supply system to the nearest city. And HRC noted that these allegations were not disputed by the state of Peru, who could not justify the inference other than to referring to the construction of the water wells in the what they call Takana project. And after this, the HRC established that the admissibility of measures which substantially compromise or interfere with the culturally significant economic activity, and economic activity is important here. of a minority or indigenous community depends on whether the members of the community in question have had the opportunity to participate in the decision-making process in relation to these measures and whether they will continue to benefit from the traditional economy. And this two sentence is very important. And probably number two is the most important. The minority should continue to have outcome from their traditional livelihood. If not, there will be a violation. And in addition, to participation in the decision-making process, HRC states that the participation must be effective, which not only involves consultation, but that the members of the minority gives their free, prior, and informed consent. So this is important, and I will not say that Norway is at that point today. Free, prior, and informed consent is still not a part of Norwegian internal legislation, but at least when it's a huge encroachment in the land of indigenous people, according to the UN Human Rights Committee, the indigenous people need to give their consent. Or the state have a duty to get the consent from the indigenous people, to say it in another way. Yeah, I'm sorry, it should have come a little bit before. But in addition to the individual complaint cases, the ICCPR 27 general comment, because the human rights community can also post general comment with guidelines, clarify that Article 27 imposes an obligation to implement positive measures of protection to the state party. This I have already said, but here is the direct reference to it. And even more important for indigenous people, the HRC states that culture manifests itself in many forms, including a particular way of life associated with the use of land resources, especially in the case of indigenous people. And this is the directly sentence who make land and resources as a basis, a material basis for the culture, and which protect the land, waters, natural resources in the same way like other parts of culture. So this is a very important statement who are repeated in several individual complaint cases. Yeah, then I should progress into Norwegian law. Now I have put up the frame for the international law. And as I mentioned, or I didn't mention probably, but in September 1972, Norway ratified the ICCPR. And it became legally binding to Norway and all other states who has ratified it in 1996, because then I suppose it was 35 member countries have signed it, and then it was come into force. And more importantly, in Norwegian law, in 1999, or we can take a little bit the backstep of the history, because before the 1990s, human rights issues wasn't the case in Norway at all, because in Norway we believe that the violence of human rights didn't take place in Europe, or at least not in Scandinavia. So these was things what happened in Latin America, in Asia, and other places. But in the beginning of, or we can go back to the 1980s, then it come a focus on the situation of the Sami people, and people start to realize that everything wasn't 100% good in Norway either. So there was a development focusing on the rights of the Sami people, and suddenly somebody start to speak about human rights, and not exactly about violation of human rights, but at least that they should be more securely protected. So there was a development through the 1990s to develop a law on human rights. It was adopted in 1999, and it was a very simple law. It just mentioned the five, or at that time it was only the three most important human rights treaties, and said that they should count as Norwegian law, and if they was in contradiction to national law, the international law should have precedence. So that was the law of 1999, and one of the treaties who come into that law, it was the ICCPR. So that's the way Norway did it, and of course, when Norway adopted the law, I don't think they was thinking very much about the land encroachment, and that the Norwegian Expropriation Act should have problem in contradiction with the human right commitment. But that was something what the Norwegian ministries or State Department realized 20 years later. So to say it very briefly, even if the Supreme Court rules in the final instance, as it's written in the Norwegian Constitution, Article 88, case law from the HRC will have significant weight in the interpretation of the ICCPR. If the committee in a complaint case against Norway determines a violation of the convent, there is, according to the Dispute Act, a reason for reopening. So in this case, the Norwegian Supreme Court does not have the final word. And in addition, Norway adopted or amended the constitution with an article to protect the Sami culture, which read, the authorities of the state shall create conditions enabling the Sami people to preserve and develop its language, culture, and way of life. And it said that this constitution article should be understood in the same way as ICCPR Article 27, which is the model for that provision. So in Norway, Article 27 means that even if the Expropriation Act or an expropriation interference, which in practice means that you in a forceful way buy land from someone, and the condition in Norway, in Norwegian law, is that it's undoubtedly is more benefit than damage for the society at large. And the person who is affected, he should of course receive full compensation, but that compensation is very seldom land, it's usually money. So according to Article 27, this will still not be legal if it violates the rights of ethnic, religious, or linguistic minorities to practice their culture. Article 27 has been applied by the Supreme Court of Norway in a significant number of cases. In 4 cases prior to this Fosen case, which I'm focusing on, the threshold for intervention was said that it was too high, that the particular expropriation case was illegal. But already in 1982, before the Human Rights Act, the Supreme Court said that the provision count for Sami people, and particularly for Sami reindeer husbandry. But the Supreme Court didn't find reason to emphasize it heavily enough that it gave any outcome for the Sami people in the court case. So it was together with that rather famous or infamous Alta hydropower case where the question was raised first time. And at that time, the Supreme Court found that there was no reason to halt the construction because of the ICCPR. The time do not allow me to go into the other cases, but we can just briefly put up what you could learn from the previous cases. That, first of all, the Sami in Norway are covered by the Article 27. The extent of the intervention is important for whether there is a violation, and that the provision cannot be applied to administrative reindeer husbandry regulation, because there was a case up in 2007 when it's an internal case of regulating or reducing the reindeer, the numbers of reindeers. The Supreme Court said that Article 27 cannot be used for protecting that kind of interference. So let's go into the recent norms from the Fosen case. And first we can look on what does it take for an offense to exist, or when is Article 27 violated. The Fosen case concerns an industrial interference that can be compared with the Puma case, but without being that huge or extensive. The question at stake is whether the interference violates the rights of 2 reindeer herder units to practice their traditional livelihood, the reindeer husbandry. Article 27 sets a threshold for the administrative discretion of the government or the ministry, and based on the precedence of the Act, in Norwegian law, a decision that passed this threshold or level will be unlawful or invalid. In order to decide where the threshold for violation lies, the Supreme Court applies case law from the HRC. And the most relevant here is the aforementioned Puma case. So after the first voting judge, the judge who is reading the judgment, have quoted and translated a substantive negative impact, the judge states. Against this backdrop, my conclusion is that whether there will be a violation on the right of Article 27 if the interference have a substantive negative impact on the possibility of culture enjoyment. Actually, this is nothing new. It's just a translation from the Puma case. But in any case, it's important for the Norwegian internal law that this is repeated. And Furthermore, the court states that the interference does not have to be as extensive as in the Poma case. The threshold is still high, but not as high as the wording of the act, the wording of the provision, because the wording say deny, but the Supreme Court say if it's have a substantial negative impact, it is enough. And also important, the Supreme Court does not emphasize the consequences of the interference alone to determine whether there is an interference. The court states that the interference must be seen in connection with other measures, both earlier and planned. It is the different activities taken together that may constitute a violation. And that is also very important. It's not that clearly said in the Human Rights Committee's case law, although it's mentioned in one of the Landsmann cases. But it is in direct contradiction with previous Norwegian internal Supreme Court cases. And also, the Supreme Court is more specific and just telling that focusing on the substantive negative impact, because you need to determine exactly where the violence appear. So in that case, the Supreme Court go into the economics of the culture-based industry or livelihood. So in practice, the threshold is passed when the members of the minority no longer is guaranteed an economical outcome from their Sami way of life. Again, quoting the Supreme Court. The economy of the husbandry is therefore relevant in a discussion of a possible violation. The relevance must be assessed specifically in each individual cases and must depend, among other things, on how the economy affects the cultural practice. In my view, the Supreme Court judge states the right in Article 27 are in any case violated if a reduction of the pastures deprives the herders of the possibility to carry out and practice that may naturally be characterized as trade. So important here is that the Supreme Court say in any case, so that means that the threshold may be lower. Consultations are also a factor that is a part of the assessment, but not as important that we could suppose. If the consequences of the interference are high enough or seriously enough, consultation does not prevent the violation. And this is very interesting because it means that even if the constructors of the energy company manage to get a consent for intervention from the indigenous people, it will not be lawful if the interference is huge enough. So it means that you could not put a huge amount of money on the table just to get consent. And the reasoning for that is that you should protect the culture, not only the individuals who is exercising reindeer husbandry today, but you should also protect the future reindeer herders. and that will not help if the herders today can give their consent. And next thing, what is interesting here, it is the proportionality assessment. The Supreme Court here again refers to the POMA case, where it stated that the consideration of economic development cannot undermine the right protected under ICCPR 27. So this means that there is no room for proportionality assessment. It means that if there was a room for that, it will more or less always just be a question of money again, because you could argue that, for example, this huge wind power plant is very important for Norway's economic, for the green shift, and particularly for the energy crisis in Europe now. And two small reindeer herder units, they don't produce much money for Norway. But the Supreme Court say that you cannot do that evaluation. If the threshold is passed, it doesn't help how important the power plant is for Norway, for the green shift, or for the global energy situation. This is again quoting from the decision. Against this backdrop, the clear starting point must be that there is no margin for appropriation is granted under Article 27, and that is does not allow for a proportionality assessment, balancing other interests of society against the minorities' interest. This is natural consequence of the reason for the provision, as a protection of the minorities' population would be ineffective if the majority population were to be able to limit it based on the legitimate needs. So this is also one of the reasons that the Expropriation Act cannot be used. You cannot use money here to compensate loss of culture. And also relevant in this case, because the case passed three instances in the court. First, the district court, then the Court of Appeal, and then the Supreme Court. And in the Court of Appeal, they find the interference lawfully, and that was because the energy company promised to pay for winter feeding in the reindeer, because it's the winter pasture who was destroyed. So the energy company should pay for feeding the reindeer for 2 months in the winter. To that, the Supreme Court say that relevant here is that, or that's not the quoting, but relevant here is that the proposed model for winter feeding differs significantly from traditional nomadic reindeer husbandry. It therefore appears that uncertainty to whether such a system is compatible with reindeer herders' rights to enjoy their culture. In other words, the Supreme Court say that this is not a traditional culture to collect the reindeer in a big group for 2 months in the winter and feed them. Therefore, it is not a way to compensate or to mitigate the interference. Or they call it remedy measures in the court, and this is not acceptable remedy measures. So I'm on the way to summing up now. So I will just state the 4 or 5 norms I have spoken through from court case. First, in addition to the size of the interference, the court emphasized the cumulative effect of the interference, not only the particular wind power plant, but also what have been done before and what other things can come into the future. They emphasize the consultation, even if it's not decisive for the decision. And whether the minorities still have economical benefits from their traditional trade, and that any mitigation measures do not contribute reindeer husbandry or cannot be used if they derivating significantly from traditional Sami reindeer husbandry. And here it's probably number 3 who is the most important of them. And in addition, of course, also I could point on the proportionality assessment, that is a 5th point, and that means that the green shift is not an argument here. Yeah, when we know about the situation in Norway today, the power plant is still, or the windmills, or what we call them, turbines, they are still rolling there. Nothing have happened 1 year after the court decision. So, having that in mind, it's difficult to imagine that the wind turbines can continue to roll, at least to a significant extent, without questioning being asked about the Norway's ability and willingness to safeguard the material basis for the culture of the country's indigenous people. And not at least, and that is not an indigenous issue, for Norway's ability to uphold its own national court decision, because actually the Ministry of Oil and Energy, they try to pass around the court decision and say that it's possible for reindeer husbandry and power plant to live side by side in the future, even if all kind of such possibilities have been presented for 3 different courts, which could not find that there is such solution. Before I come to end, I just will show you, for those who is more interested, there is presented a report from the Norway's Institution for Human Rights, and this is in English, and it is published in full text online. So if you Google on that name, you will find them. And also there is an article in the International Journal of Minority and Group Rights written by me, more or less, on the topic which I am presenting on here today, or to say it another way, my presentation here is based on that article. Unfortunately, it's behind a paying wall, but in any case, you will find the whole story there. So then I just say thanks for the attention, and ready to answer some questions. See, there is 7 minutes left.